Joining us today, I'd like to welcome Paige Clausius-Parks. She's the Senior Policy Analyst for Rhode Island Kids Count. She's responsible for their policy work related to education and economic well-being. Prior to joining Rhode Island Kids Count, she served in a number of related positions, including Director of Advancement at Books Are Wings and Network Director at Youth in Action. She has a Bachelor of Arts from Providence College and a Master of Education from Harvard University, and she's one of the key leaders in Rhode Island trying to drive change in education. We're really delighted to have her as a panelist today. Also joining us is Hannah Stern, which is our policy associate here at the ACLU of Rhode Island. In addition to doing lobbying on civil liberties issues, she also handles our research and data analysis. And then joining me on the back end to help facilitate is Megan Cachadorian. She's a veteran staffer who manages our legal intake and our volunteer program, as well as most aspects of office administration. And today she's going to help me run the slideshow. Thanks so much for stepping in to do that. Also joining us is Steve Brown, last but not least, of course. He really needs no introduction. Today, he's one of our panelists here to share some info and insights on the various pieces of education legislation related to civil liberties. And so without further ado, I want to welcome him. He's going to say a few words about education and civil liberties generally, and also talk about legislation related to field trips. Hi, Steve.
Hi, Nicole. Thank you very much. And thank you, everybody, for joining this town hall. I hope you find it informative. The title of the town hall is Suspensions, SROs, and Student Privacy, but we're actually going to be covering a lot more ground than that. It's really amazing to me how many critical civil liberties issues there are that intersect with education, with public school, with students. It's not just student discipline or student privacy that's in the title, but we're also dealing with issues relating to school financing, school curriculum, school staffing, and so on. It's the reason that at our office, we do spend a lot of time on educational issues. We're in court a lot of time on student rights issues. Right now, I checked half a dozen of the cases on our docket are school related. But we also spend a lot of time, as you'll see today, on legislative issues relating to education. And it's not just the intersection that with so many civil liberties issues that I think makes it a priority for us. It's also the importance of civil liberties in the educational setting, since this is really where students learn about their civil liberties or their lack of them. There's a great quote from Justice John Paul Stevens that I like to use a lot. He said this in a dissenting opinion in a very important student privacy case that the Supreme Court handled many years ago. Unfortunately, he was on the losing end of it. But what he said was, the schoolroom is the first opportunity most citizens have to experience the power of government. The values students learn there, they take with them in life. And that is really true. You know, when you look at how civil liberties are often in such peril, when you see so many adults who aren't aware of what their civil rights or civil liberties are, at least part of it, I think, is due to the fact that they may have spent 7 or 8 hours a day in some of the most formative years of their lives in a setting where violations of civil liberties were sort of taken for granted. And if you grow up with that, I think it's a lot harder to understand why these rights are so important. And so that takes us to, to the purpose of this town hall, not just to educate you as interested people and advocates on civil liberties legislation affecting education, but in the hope that at the end of this, you'll be primed and prodded to do some advocacy yourself, talk with your legislators about these issues that are of importance to you. So with that introduction, I will jump right into the first issue among many that we're going to talk about, and that is school field trips. You know, the cornerstone of our democracy is, one of the cornerstones is the idea of a free public education. But how free is it really? And what we found over the years is that school districts regularly try to charge students for their education in various ways. And it's a fight that we've had on a whole array of issues. We've had school districts charge students if they need to go to summer school. They've tried to charge students if they want to take certain exams like advanced placement exams. They charge for various aspects of extracurricular activities. And the question becomes, can they do that? For the most part, the State Department of Education has been very strong in saying, no, free public education means what it says. It should be free. But one issue where this has cropped up more and more as a battleground is with school-sponsored field trips. And so a couple of years ago, as a result of an opinion that the Department of Education issued, legislation was introduced in the General Assembly designed to set some parameters on how schools could deal with field trips and the costs associated with it. So there is a bill pending in the General Assembly. It's the one that's on your screen that has already passed the House, and it's a bill that we're strongly supporting, and it lays out standards. The most important thing it does is it says school districts cannot charge students to participate in school-sponsored field trips. We have had complaints of students who've been left in a classroom while the rest of their classmates go on a field trip because they haven't been able to afford the cost of participating. If this bill passes, it will be law that that is illegal. It cannot be done in Rhode Island. What it does say is that school districts have the authority to request donations from parents in order to help fund these trips. Obviously, they can put it in their school budget. But the bottom line with passage of this bill is that students won't have to worry, their parents won't have to worry about hard-earned money having to go to pay in order to make sure their child isn't left behind when the rest of the class goes on a field trip. So we're hopeful that the Senate will also pass this bill and it will become law before the session ends. Oh, you're on mute.
Thanks so much, Steve. I want to welcome Hannah back, Hannah here to talk about the one-to-one bill and student privacy. Hi, Hannah.
Hi. Hi, everybody. Thank you so much for joining us today. We're really excited to talk about all of this legislation. And I'm particularly excited to talk about this piece of legislation, actually. I think this is an issue which we've really seen amplified and which has really gained a lot of traction, especially over the last year, as we saw pretty much 100% of public school students in Rhode Island and the United States transitioning to mandatory virtual education. But for a few years now, we've been really concerned generally about the lack of comprehensive privacy protections that students have when they're using, in particular, school loan devices or computers like Chromebooks or MacBooks, which are owned by the school but assigned to an individual student for home and school use. So what we've done over the past few years, we've done 2 comprehensive reports on this. The most recent was released last year in September, was we tracked the privacy policies for school loan devices for every single district in Rhode Island. And what we found is that a majority do not provide privacy protections really at all for students. When we reviewed them last year, we found that 67% of school districts do not have restrictions on school remote access to the camera or microphone of a school loan device, essentially allowing themselves that ability implicitly. This is really concerning, again, especially since so much of education was taking place in the private home, especially over the last year. And then we also found that 64% of districts were telling students in their policies that students have no expectation of privacy when they're using these devices whatsoever. And again, in the private home, this is especially concerning. And it's also possible that for some families, these could be the only devices that they have available in their household. And parents and guardians might need to use it to make medical appointments or file for unemployment. So such benign behavior, we think, really should not be subject to possible really inappropriate school spying. Especially over the last year, again, we've gotten so many emails from parents and families really concerned about this issue. And what we've had to tell them is that there's no state law which guarantees any privacy protections to students when they're using these devices. And because every district is so different, because the policies are so disparate, students really just have a patchwork of protections, which are dependent just on where they happen to live. So this bill is really important. It would statutorily provide these protections for students, provide privacy protections for students when they're using school-owned computers and school-owned devices, and really clarify and ease the very valid concerns that students and parents have had about how they are being protected on these devices. So I think I'll leave it at that. Thank you.
Thanks so much, Hannah. I'm gonna introduce Paige to talk about out-of-school suspensions and school discipline. Hi, Paige, thanks for joining us.
Hi, Nicole. Thank you so much for having me. I'm so excited to be a part of this panel and this discussion. So for House Bill 5234 about out-of-school suspensions, this bill would prohibit schools from suspending students in grades 5th grade or below, including preschool students, because believe it or not, students can be suspended in preschool. So this would prohibit that unless they possess, the current bill says unless they possess weapons or narcotics or are found by a psychologist or other mental health professional to be in danger, to be endangering to other students, administrators, or teachers. The bill also requires the use of restorative justice practices to address student behavior. I've been really grateful, and it's been a wonderful experience to work with the ACLU to further improve this bill even more, for a sub-A to be introduced, which would prohibit out-of-school suspensions for our youngest kids if the school administration, in consultation with the school psychologist, deem a child's behavior to be a safety threat, and for those cases that involve alcohol, illegal drugs, or controlled substances, to be on a case-by-case basis. So why this is important for anyone who's ever cared for or loved a small child, I think our intuition tells us that children's behavior at this young, they're developmentally and age appropriately, perhaps not even, they're still learning what their behavior means. So it's counterintuitive to think that a child will be sent home from behaviors that they may not understand in ways that does not actually address the root cause of their behavior. So in Rhode Island, there has been some progress made to improve and limit the use of out-of-school suspensions. In 2012, legislation was passed that would prohibit the use for suspensions for absenteeism. Again, counterintuitive. Why would you send kids home if they're absent from school? But that used to be the law. Luckily, that has changed. In 2016, more legislation was passed that would limit out-of-school suspensions only for when a child's behavior poses a demonstrable threat to students, teachers, or administrators. And it also requires school districts to disaggregate their suspensions data and to create a plan for any disparities that may be seen. Department of Ed also has a lot of resources on their website about how to limit out-of-school suspensions, information and resources about restorative justice practices. However, despite all of those efforts, we still see that students are being suspended for nonviolent offenses. These may include what's considered disrespect or insubordination. In the 2019-2020 school year, we saw, again, large disparities in use of out-of-school suspensions. Our students with disabilities were 17% of the student population last school year, but they were 33% of all students suspended. We also see similar disparities based on race and ethnicity. So we are in support of this legislation because we believe to improve school climate, we need to decrease the use of suspensions, and we need to provide schools with alternative measures to deal with the root cause of students' behaviors. And that includes using positive restorative justice practices and also increasing the access to school-based mental health professionals. The students need to be in school. The discipline to help improve our school climate needs to be age and developmentally appropriate. Out-of-school suspensions just don't accomplish that. So, thanks.
Thank you so much, Paige. That was excellent. Let me go back. I'm going to welcome Hannah back now to talk about a couple bills related to school resource officers. Hi, Hannah.
Hi again. Thank you so much, Paige, for that really wonderful summary of that legislation. So I think that the placement of school resource officers, or SROs, on school campuses are kind of a parallel issue to to school discipline reform. And our organization is opposed generally to the imposition of these personnel, these law enforcement personnel in the form of SROs onto school campuses. And as Paige noted earlier, the same disparities that we see for students of color and students with disabilities and LGBTQ students in suspension and discipline data is really also mirrored through interaction with SROs. And it just forms the backbone of the school to prison pipeline, which is a really big issue when it comes to disciplinary protocol and SRO placement. In just the last year, just for example, our organization, the ACLU of Rhode Island, filed 2 lawsuits over unlawful conduct of SROs in our public schools. One was on behalf of a special education student who was thrown to the ground by their SRO, and another was on behalf of a Black female middle school honors student in Pawtucket who is unlawfully handcuffed by her SRO. So the presence of SROs is really concerning. We see the same disparities that we see in disciplinary data mirrored throughout SRO interaction, and it's a really, really concerning issue, especially because law enforcement personnel just really shouldn't be on our school campuses in general. SRO presences are concerning because the money being used for SROs simply just could be going to better places. It's not a secret that there is a huge lack of mental and behavioral health personnel in schools. Some of you may remember the incident at Kickamuit Middle School a few years ago, actually, where the school closed because enough teachers called out. And all of those school personnel said that they needed counseling support for their students. Those were the personnel that they desperately needed on campus. But the immediate response was to bring in an SRO, which was just inappropriate and contrary to the needs of the school environment. And then finally, just as the end of the SRO overview, SROs just are not trained adequately or appropriately in adolescent mental health. They can inappropriately redefine otherwise normal adolescent behaviors into issues of criminal justice, again, subjecting students to the school to prison pipeline when they just need is behavioral and social emotional support. So the 2 bills that I'll briefly talk about, one of them is supported by us and one is opposed. The first one that we're supporting is a piece of legislation which would provide $2 million for the hiring of school social workers. Currently, the state of Rhode Island does provide state reimbursement for the hiring of new SROs. This reimbursement structure ends next year. And on the conclusion of that program, this bill would instead provide a pocket of funding so that schools can be reimbursed if they're hiring social workers or mental health support for students rather than the school or rather than the state only providing funding just for SROs. And then the second bill, which we oppose, is one which would indefinitely extend the SRO reimbursement program, which we think is inappropriate. We don't think we need more SROs. We need, like I said earlier, we need more mental health support. We need more counselors. We need more social workers. We need more school psychologists. And so we opposed this piece of legislation, which would indefinitely extend that reimbursement structure, essentially encouraging schools to continue hiring SROs when what they really do need more desperately are personnel who are appropriately trained in adolescent behavioral health.
Thanks so much, Hannah. Before I welcome Paige back to also talk about another SRO bill, I wanted to say, I wanted to remind everyone that you can ask questions at any time. So I know there's a couple queued up. There's a Q&A button at the bottom. And the reason I'm mentioning this also is because we're so used to talking about this stuff on our end that there might be things that we don't realize you don't understand, that people don't understand. And so we really welcome the opportunity to clarify things. So yeah, I wanted to welcome Paige back to talk a little bit about a little bit more about SROs and data reporting. Thanks.
Great, thanks. Yeah, Hannah provided a great overview around school resource officers and their use in schools. And we are in strong support of this next bill, which is 5827, which would require the Rhode Island Department of Education to coordinate with the Attorney General's office to collect and publicly report data concerning the number of school resource officers that there are in each school district, the use of force that SROs may have against students, The number of student arrests and the referrals to law enforcement or courts, and to disaggregate that data by age, grade, race, ethnicity, gender, disability, and language status. So why this bill is so important and why we are so strongly supporting of it, besides this being a data organization, right? We love data. We also know that data is a really powerful tool to help shape policy. We know from national research that the presence of school resource officers worsens the school climate. It increases disciplinary actions. It disproportionately impacts the academic outcomes of students of color and contributes to the school to prison pipeline that Hannah mentioned. But the data that we have here in Rhode Island is collected in inconsistent time intervals, and it relies on reporting from the U.S. Department of Education, Office of Civil Rights. And those survey topics can be subject to change based on the federal government and the administration of that time. The timing intervals may change, and we feel like it's very important to have our own local data so that we're able to write and drive our own policies that are going to help improve school climates. Some data that we do have that's important to note. So in Rhode Island during the 2015-16 school year, we saw large disparities in student arrests and referrals to law enforcement based on race and ethnicity. So in that school year, Black students were 8% of the student population, but they were 23% of the students referred to law enforcement and students referred to school-related arrest. Hispanic students were 24% of the population, but they were 47% of the students referred to law enforcement and 36% of students that had school-related arrests. As opposed to white students. So white students that school year were 60% of all students enrolled, but they were only 18% of the students referred to law enforcement and 25% of students with school-related arrests. If you look at our kids that have individual education plans, they were 15% of the student population, but 22% of the students referred to law enforcement and 29% of students with school-related arrests. We know that students' arrests in juvenile detention increases the students' likelihood of future arrests. It decreases their likelihood of completing high school and may result in some really long-lasting detrimental consequences that last their whole lifetime. That could include restricted eligibility for federal grants and student loans, barriers to college enrollment, barriers to college employment. So we really need to look at how our school resource officers contributing to this school to prison pipeline. We need to have our own data so we know what's happening locally, and we can see the impact of any policy changes we may have. Also, I think it's just human nature. If we don't have data, we will rely on just our own personal experiences. Oh, my sister's a police officer, my cousin, my neighbor, my brother, they're good people. I don't understand why this is an issue. But this is an issue because this is not about individual police officers. This is about using the system of policing and law enforcement as a discipline tool in our schools. We need to understand how law enforcement impacts school climates, and we need to be able to figure out and better allocate the resources that Hannah mentioned to address root causes, to address mental health and behavioral needs, and not rely on harsh discipline practices, including the use of law enforcement in our schools.
Thank you, Paige. Sorry, I'm coming back here. There I am. I want to bring Hannah back to continue sort of this discussion about law enforcement in schools. Hi, Hannah.
Hi again. Thank you so much, Paige and Nicole. So as we've been really talking about, especially during the last few bills, the increasing of SRO presence or law enforcement presence and the broadening of school disciplinary measures are just two kind of larger pockets of policy that we generally oppose when it comes up in the legislature, and which are overwhelmingly really, really concerning for us. And sometimes these policies arrive in legislation in sort of roundabout ways that build even more concerning programs in them. So this is one of those pieces of legislation. This bill is a great example of this particular concern, but a very bad bill overall. It would essentially create a school security committee that would be responsible for facilitating programs for the presence of armed security personnel, and it would mandate really expansive school surveillance initiatives. When we testified on this bill, we noted, again, the disproportionate impact of disciplinary and enforcement protocols on students of color and students with disabilities and LGBTQ students. And both the armed personnel and the surveillance initiatives, they both have a really horrible capacity to only exacerbate these disparities, and in the worst application to falsely or inappropriately criminalize students through, for example, attempts to identify students as safety threats. So surveillance is also a student First Amendment issue. We think that it could chill really important speech and student intellectual freedom. It could dissuade students from engaging in certain activity groups or having private conversations. And it could also just undermine a student's expectation of privacy while they're in their school. So this bill touches a lot of civil liberties issues which intersect with student rights in a really negative way, and we did oppose it. And then the next piece of legislation that I'll go into that I'm going to talk about is kind of similar to the School Security Committee bill, which in the sense that we just tend to be very wary of pieces of legislation, again, that would increase SRO presence or amp up disciplinary procedures. Again, this is one of those bills. And I think it's also a really interesting one to talk about because it illustrates something really important, which is that bills can try to take on these very big topics that are deserving of attention, like bullying, but that regardless of the intention of the bill, the language can still be really, really harmful or have consequences which are antithetical to student civil liberties. So this bill in particular does that because it proposes to expand the basis under which students can be suspended, which, as we heard earlier, the current standards are already too broad. It would explicitly engage SROs in the school campus, and very concerningly, it would give schools jurisdiction to address incidents which happen off of school grounds. We just think that schools shouldn't have the ability to 24/7 monitor students or punish them for incidents which have no bearing on the school campus itself. So this was additionally a provision that we objected to. And of course, again, we expressed concerns that the disciplinary protocol in the bill and the expansion of SRO presence would again most negatively affect marginalized students, like students of color, students with disabilities, and LGBTQ students. So this was just another way that the expanding of SROs and the expanding of disciplinary protocol, which we're opposed to, showed up in the legislature this year, and we did oppose this bill as well.
Thanks, Hannah. I'm going to bring Paige back to talk about the divisive concepts bill. Thank you. Hi, Paige.
Thanks. Yes. So we strongly oppose this bill. House Bill 6070 would prohibit the teaching of what they term divisive concepts and would mandate that any contract, grant, or training program entered into by the state or any municipality would include provisions that would prohibit teaching divisive concepts and prohibit making any individual feel discomfort, guilty, anguish, or distress on account of their race or sex. And the bill defines divisive concepts as those that discuss racism, sexism, and other topics that are often included in diversity, equity, and inclusion training programs and anti-racist curriculum. So we strongly oppose this bill. Rhode Island student population is increasingly diverse, and it is beautifully diverse. In October of 2020, 46% of public school students were students of color. Having culturally relevant and historically accurate education that reflects and celebrates the identity of our students can have a positive impact on school climate, student engagement, and their academic outcomes. And schools have this really unique role in becoming leaders and being on the forefront of having these really important discussions about race and sexism and oppression. And it's a great opportunity for our students to be able to learn from each other and to be introduced to accurate information so they become well-informed citizens. And providing this curriculum is one step. Providing these training opportunities is a step towards the goal of increasing race equity in our state. Unfortunately, bills like this have been introduced all across the country. And it's so sad to see that it was introduced here in Rhode Island. We have a lot to learn from our neighbors. So Connecticut, right next door, in 2019, they passed legislation that did the exact opposite of this bill. Their legislation required all school districts to include African American, Black, Puerto Rican, and Latino studies as a part of the curriculum. And that work was led by who's now our current U.S. Secretary of Education, Miguel Cardona. So I'm very optimistic that we will see further support for culturally relevant education. And so we strongly oppose this legislation. We feel it is misguided. We know that it is harmful because anti-racist teaching, diversity teaching, encourage students to learn and analyze, to value the experiences and stories of different racial groups, and to transform any feelings there may be about guilt into a commitment to dismantle racism. And we know that policies and practices that are racially aware and equity-centered can exacerbate many of the inequities that we see in our education system. And this bill just takes us too far away from that goal.
Thank you so much, Paige. Hi, here I am. Before we go into the Rhode Island Promise Bill with Paige and Steve, I wanted to mention that, you know, we're talking about a lot of different legislation. And in fact, this isn't even all of the bills. I think we have about 3 more bills to discuss before we get to the rest of the program. But, you know, there are a number of other bills on the website. This is just sort of the ones that we decided to hone in on. So with the questions, I see your questions in the queue. Thank you so much. Keep them coming. They're great. And with that, I want to welcome back Paige and then Steve to talk about the Rhode Island Promise Bill. Thank you.
Sure, I can go first. So Rhode Island Promise is a scholarship program that was introduced as a pilot program a few years ago, which would provide a last dollar scholarship for students to attend the Community College of Rhode Island for free for 2 years. Rhode Island Kids Count is also the lead convener of the Rhode Island Alliance for College and Career Readiness. And this alliance advocates for budgetary investments that will increase college access, college and career readiness with the focus on race equity. So we were, as an alliance and as an organization, in strong support of making the Rhode Island Promise Scholarship permanent. It was due to sunset before the pandemic. It's extended for 1 year, and now this legislation 5224A, and also in the Senate Bill 79, and also the sub A, would make this scholarship permanent. So we are in strong support. We feel this is one of the tools to help increase equity and access to post-secondary opportunities for low-income students and for students of color. It's one aspect, which would be decreasing the financial barriers, but we know there are many, many more steps that we need to do to improve college and career readiness, but this is an important one, and we need to have this to be permanent so that we can continue to improve this program and increase equity throughout this program. Steve, you want to add in?
Hi, Steve. Hold on, let's make sure. Muted. Got it unmuted. There you are.
Paige did a great job explaining the program. I just want to add the bills that made it permanent included amendments that we had strongly supported. You know, as great as the program is, we received a couple of complaints a number of months ago from students and their parents, students with disabilities. The program is a 2-year associate degree program, but for some students with disabilities, they simply cannot have a full workload, and it takes them longer than 2 years to graduate. Unfortunately, the way the program was set up, the free tuition expired at the end of 2 years, even if the school itself acknowledged that the student, because of their disabilities, needed more time. After we raised complaints about that with CCRI, they acknowledged that that was a legitimate problem that needed to be addressed. Separate legislation was also introduced to address that issue and make it clear that the program had to provide reasonable accommodations to students with disabilities, including allowing them to take longer than 2 years in order to participate. And I'm very happy to report that both of the versions of the bill that Paige talked about were amended. That's why they're so-called sub-A bills, to include these protections for students with disabilities. So we're very hopeful that when these bills pass, students with disabilities will have the protections that they are entitled to under anti-discrimination laws.
Thanks, Steve. I'm going to bring Paige back to talk about teacher diversity.
Great, thanks. So House Bill 5699, called the Increasing Opportunities for Teachers of Color Act, would provide $2 million for a scholarship fund to prepare students of color to enter the field of education. We strongly support this bill. And why? It's because we have seen the research, we know the research, that educators of color greatly contribute positively to the educational experiences of all students, but especially for students of color. Students of color demonstrate long-term academic achievement, including higher reading and math test scores. There's decreased likelihood of dropping out of high school, increased likelihood of going to college, and increased social and emotional development in classes that are led by educators of color. We've talked before around how many students of color there are in our public school system. 46% of students are students of color. However, in Rhode Island, we know that 96% of our public school teachers identify as white. So we see it's a great need here to increase the number of educators of color in Rhode Island. The Annenberg Institute recently released a study that showed teachers tend to work close to either where they grew up or close to where they completed their teacher preparation program. In Providence, for applicants for Providence Public Schools teacher positions, nearly half of them were trained in a Rhode Island teacher prep program. So it makes sense that we invest in opportunities for locally to recruit more people of color to become educators. Rhode Island needs to encourage more people of color to pursue the career of education, but then to also support them to stay in that field. We need to support our educators of color. We need to also increase our cultural competencies for our current educators in the system, as well as we talked about, decreasing disparities around suspension rates. We need to increase communication and the power that our families and students have in our education system. And if we're able to do all of those things, we believe that we'll be able to see and make some great progress towards decreasing the academic disparities we see based on race and ethnicity.
Thanks, Paige. To wrap up our discussion of the different bills, I'm going to bring Steve back to talk about the Right to Education bill. Hi, Steve.
Hi, thanks again, Nicole. And this takes us full circle. We started with the field trip bill and the issue of equity, financial equity, and we end with the same issue with the right to an education. Well, isn't there a right to an education? Well, you'd be surprised how little there is in terms of a constitutional right to an education. If you read our state constitution, it sure seems to give people a clear right to an important education. What our state constitution says in relevant part is the diffusion of knowledge being essential to the preservation of their rights and liberties, it shall be the duty of the General Assembly to promote public schools and to adopt all means which it may deem necessary and proper to secure to the people the advantages and opportunities of education. I mean, that sounds like great language. The problem is 25 years ago, some school districts recognized that the state school funding formula, which is mostly how schools get funded, really benefited wealthier districts, wealthier communities, and had a deleterious impact on communities that were not as wealthy, and particularly communities that are not as wealthy also include communities which are more maintained of people of color, poor people. And so there was this clear disparity in the education that were being provided students. So some school districts themselves filed a lawsuit using the state constitutional language to argue that the General Assembly was not doing what the mandate required under the Constitution. Unfortunately, our state Supreme Court ruled against the school districts. And what it essentially said was, despite all that wonderful language, what it actually says is it's up to the General Assembly to do it. It's not for the courts to decide whether it's being done properly. And so, sorry, but there's nothing you can do in the courts to vindicate what seems to be this essential constitutional right. As a result of that, there's been legislation introduced for a number of years, including this one. It's a constitutional amendment that would clarify and strengthen this language in the Constitution to not only make it clear that this right to an education means something, but it also explicitly allows individuals and school districts to sue, to go to court in order to vindicate that right. There are courts across the country that have interpreted their state constitutions in a much more robust way than our state Supreme Court has. But now because of those court decisions here, this is the only remedy available. So it's an issue that's been pushed for many, many years, and it's going to continue to be pushed. I'm not sure it will get passed this year, but it's a continuing effort to make sure that all this wonderful flowery language in our Constitution actually means something to students so that they can attend schools that are equitable across the board, and you don't get an education based on how wealthy the district is that you live in. So with that, I think we're going to move it, now that we've gone over all these bills, we're going to have Hannah tell you what you can do if you're concerned about any of these things, and then we'll get to questions and answers. Hannah?
Thank you. Yeah, so I'll just briefly go over some of the tools that we have on our website, and then also what one really impactful thing you can do, which is contacting your legislators about the issues that are really important to you and the pieces of legislation that are really resonating with you. So at the conclusion of this town hall, you will receive an email that will take you to an action that you can take to send a letter of support in favor of the out-of-school suspension limiting bill. So that's one thing that you can do. You can send an email directly through that platform that we'll be sending out to you after this town hall is over. But then we also have a lot of resources on our website. We have an entire Advocacy 101 section, which will teach you how to lobby on all the issues you care about, education or otherwise. This is just a sampling of the buffet of information that is on our website. We also have information about how to remotely testify, since our entire legislature has been remote for this session, and the procedures for testifying and submitting testimony are just a little bit different. There's a lot of information on tips for testifying, how to write to your legislature, just how the legislative process works. So there's a lot of information there that'll just give you a really broad overview of the legislative process. And then there's also, for the students in your life, or just for your own knowledge, if you're interested, we also have an entire Know Your Rights section on our website, which includes a lot of information about civil liberties and students' rights. So there's pamphlets on students in the First Amendment, students in privacy, students in technology, school discipline. And so if you have any questions about that afterwards, there's again a really broad selection of resources that we have on our website accessible to everybody about a lot of the topics that we've covered today.